Howdy, y'all. Happy Wednesday. Caught Scott off guard with that one. Yeah, so we're here, a little informative video. I haven't done one of these in a little while, but this is a pertinent and kind of important subject, especially for foreign nationals trying to get their work authorization here in the U.S. Scott's fresh back from an adjustment of status interview, which was approved. Congratulations.
Was approved and on point. The applicant in that case hadn't gotten her EAD yet, despite being here for 6 months pending.
Yeah. So how long was that case pending for in order to get an interview?
It was like 6 or 7 months for the interview.
6 or 7 months.
Yeah.
Okay, that's not bad. At least I have a couple cases in Santa Clara pending much longer than 6 or 7 months, but that's good to hear. At least the Los Angeles field offices are getting it together and pushing through some cases in a timely manner. But, I mean, as, well, I don't know if many viewers will know, but there is a significant delay on, I don't know if it's a service center, USCIS, but that's really kind of just getting into the weeds. But there's a significant delay in the processing of employment authorization cards. We used to see about 4 to 6 months for these cards to be issued. Now we're seeing almost upwards to 8 months and even longer. So, Scott, my question is, first off, what can someone do to try to speed up, I guess, the issuance of an employment card?
Sue. You can sue the government. File a petition for a writ of mandamus, and that can help speed up the process of getting your EAD.
Now, what is, I don't know if we touched this on a past video, but just quickly, what is a writ of mandamus?
A writ of mandamus is a petition you file with the court, and you are basically suing the government in federal court, saying that you applied for something with the government and they owe you a response. Now, you're not telling the judge you need to order the government to approve it or deny it, just that a decision has to be made because the government owes it to you.
Okay. Now, what is an unreasonable amount of time for waiting for, I guess, the issuance of an initial application for employment authorization, would you say?
It's all over the place, and that's part of the problem of why there's delays in the first place, right? It depends on the basis that you're asking for the work card, right?
Yeah.
So by law, like for instance, if you file an asylum application and you apply for a work card 150 days after you file the asylum application, that work card application is supposed to be processed in 30 days. Okay. So anything more than 30 days, I would say, is unreasonable.
Right.
And courts have said is unreasonable because Congress has said they have to do it.
Okay. What about a marriage-based adjustment of status case?
And that's where we kind of get into the gray area of mandamuses. What is a reasonable time? Well, the courts are going to look to several things. They're going to look to, first, has Congress said there's supposed to be any time? And Congress has told USCIS that they expect USCIS to adjudicate applications of really any kind within 6 months. Okay?
Yeah.
Does that mean 6 months is a reasonable time to wait for an EAD? Maybe not. Maybe not. The other thing courts will look to is what is a usual processing time. And USCIS has on their website, they post processing times for every application type. And for EADs, depending on the basis, again, for the EAD and where you filed it, they've got processing times all over the place. Now, just because USCIS says they're normally processing EADs at a certain location in 14 months doesn't necessarily mean that 14 months is a reasonable time.
Right.
So courts then look to what's the harm that's happening to the applicant, right? Someone about to lose their job.
Mm-hmm.
Is someone, and if they lose that job, are they going to be losing out on their home? Are they going to be getting evicted by a landlord? So those things kind of come into play when you're making these arguments. And it's really a holistic look. Lastly, judges also look at what's really happening on the ground, right? Are we really just putting someone who's at the back of the line and putting them to the front of the line? Because if that's the case, that's not really what a mandamus is supposed to do, because you're still making the line longer for everyone else. So you really got to show hardship, or you really got to show that this case in particular is outside the bounds of what's normal.
Right. Okay. Yeah, and we are, we, and I know other attorneys as well, are seeing success on these type of federal suits on the delays of issuances of employment cards?
Yeah, so a lot of the times the government, when they get served this lawsuit, after they get served the lawsuit, they have 60 days to respond in court to the lawsuit. So a lot of the times we'll be working with the government during that time, and they'll say, okay, listen, USCIS is trying to work on this case. We think we can get it approved before we have to respond to the government. And if that's the case, then great. We get the approval for the EAD, and then we dismiss the lawsuit voluntarily. So we'll see a lot of that. Yeah.
Okay. Now, yeah, it is. I mean, it's a good avenue. I would say if you've been waiting, if you're a marriage-based adjustment applicant and you're relying on an employment card to apply for a job, maintain your job, and you've been waiting 7 months plus, I'm thinking that's a bit of an unreasonable delay.
Yeah, it's an unreasonable day, and keep in mind, Alex, that 60-day wait time means that you're really not anticipating to get approved necessarily within those 60 days.
Right.
So you don't necessarily need to wait until like the 7-month mark. Maybe you can file earlier with the anticipation that, hey, it's been 5 months.
Yeah. And
I'm probably not going to see this for another 2 months. And you're kind of making the argument that at that 2-month mark, you're going to be suffering some hardship. You're going to be hard pressed.
Right. I mean, so long story short here is you're not just confined to the 1-800 helpline that USCIS provides, where you really get nowhere, unfortunately, or trying to send in online inquiries or written inquiries to USCIS as well. A lot of times you get boilerplate responses from them, and it does not speed up the process, unfortunately. If you're really relying on this, it has been delayed, then there is another avenue. It's a mandamus action. Scott handled these all the time. He's really good at them. If you think you fall into this category, do not hesitate to give us a call. We'd be happy to help and answer your questions.
Absolutely.
Alrighty, thanks.